I am Anne Hussein, an attorney at law. This is my second part to the presentation or our discussions, wills and estates. Today, we will be looking at making a will. Wills are actually written, and where there's no will, then the properties and liabilities fall into the estate. Now, let's get started. What is a will? There are two definitions on what constitutes a will. A will, in the first definition, means what the testator wills to happen on his death. The second meaning of what a will is actually considers the document itself. And that is referred to as the will. The will is the expression of what the maker wants to happen after his death, okay? Let's look at some things you need to know. The person making a will needs to consider who will benefit from his assets, from all that he has. It could be many individuals, it could be friends or family, it could be your wife and children. You have to consider all who will be benefiting from the things you have. The next point we have to keep on our mind, the manner to access the benefit. I would like to think about when we're making a will into various gifts. Inter-various gifts are gifts that are done during the lifetime of the testator, as opposed to the death of the person making the will. So if you want to leave property, do you want to leave the property given to the wife and then to the children? Do you want to leave all to the wife? Do you want to leave all to the children? Do you want to leave it to a third party, like a charity? Or while you're alive and you're probably of mature age at the date of making your will, you could probably add the name of that beneficiary to your transport or your deed. For example, your wife or your daughter's name, in order to avoid the whole issue of obtaining administration and taxation. Let's move on. What is the amount of benefit? If you have a bank account, is it all of the monies to one person or a part of the money? If you have a land with 2 houses, are you going to leave all of the houses to one person or one daughter? Or are you going to leave the house to the front to one and the house to the back to the other? Or are you going to let one live upstairs and one live downstairs? You have to think about all of this, because sometimes you may need to do, as opposed to when you die, that your beneficiaries have to go to have the land surveyed and divided into sublots. You could probably think about doing that in your lifetime. Another thing we can consider is the type of benefit. Well, when you think about the collection of all of your assets, you will be able to know exactly what are your different assets, like your house, your car, your shares. Then we have an important thing we have to think about is taxation. One of my friends told me the other day, oh, Anne, that's not how we draft wills in Guyana. He was simply referring to just having a will, a piece of paper appointing the executor, and the property only, that is physical property. But what about shares? That is a big issue because as I wrote recently to the shares company, they informed me that they needed to have letters of administration or letters of probate. And the letters of administration or probate has to have the statement of assets and liabilities. Don't get confused. The statement of assets and liabilities would set out everything that the deceased owns in order for the GRA to collect on estate duty. And for that reason, I think certain things are deliberately or unknowingly included in a will. For example, personal effects like clothing, because what the value are really. And then when we consider pets, in Guyana, it is not such an enlightened society, but it is getting there with so many activists and so many vets and organizations, including myself, that champion the animals' rights. You could go ahead and see the link below of my published book, My Pet Sebastian, on Amazon.com. This is just by the way, to lighten up the conversation. Yeah, so the GRA would put a value on your pet, believe it or not. It's treated like an asset, unlike like New Zealand or Australia, those European countries, even recently America, they look at it in terms of animals, your friends, your fur babies, as part of the family, as opposed to a value. So they would attach a value, especially if you're coming into the country with your pet. The airport, they would require a determination of what type of animal you have, the breed, and how exquisite it is. They would place a value on that animal. So everything is about money and collecting money by the GRA. And that process is another convoluted process. If you want to hear more about that process in upcoming discussions, you can like, subscribe, and share to my content. Let's go ahead. The taxation is necessary because as I'm speaking about the GRA, that is the Guyana Revenue Authority, the GRA, you pay estate duty. And one of the problems that people are complaining to me about is the fact that the application process, it's so repetitive and convoluted. The application process is actually back to front. We will deal with that more in an upcoming discussion. So remember to like, subscribe, and share. Okay, when you pay your estate duty, that is a tax you have to pay. You will be issued with a certificate of a proper officer, and that is what you will attach also in making an application as an executor, administrator, to administer the estate or of the deceased. So, so taxation will be relevant in making a will because the things you include there would be included on a statement of assets and liabilities, and then it's mean translation of the money that will be going to the GRA. Let's continue. What are the checklists when we look at a will? Okay, the Wills Act of Guyana, that is chapter 1202, actually sets out in a section expressly what is it that they're looking for. So a will must be in writing. And I asked the registry clerk the other day, is it going to be in a long paper or a short paper? The reason being is that they converted to the new rules system. The new rules is basically, to me, using more paper with a short. With these kind of matters, it took me require long paper, but I am just one fish in the ocean. And so he said it doesn't matter if it is long paper or short paper. So it is either long paper or short paper in writing. Obviously, you will be aged 18 years. That is a legal age to conduct business in Guyana as a legal age. It must be signed at the foot of the will at the bottom. The will must carry a signature and a date. You must have at least two witnesses, and these witnesses must not have any relationship, receive any benefit under the will. They must not be the executor. They must not have any interest or gifts or bequeath anything in the will. So two independent witnesses. So when you think about witnesses, think about two persons independent. You who are making the will needs to be fit and proper. That's a famous expression now in Guyana, fit and proper. So I put that in there in relations to capacity. That means you must be of sound mind and body. You must not be under the influence of a person or any drugs or alcohol or whatever when you're making a will. You must be able to collectively understand, or any mental disease. But sometimes we have a mental disease, you could have a lucid period, and you could make a will. Once you have a collective understanding without undue influence, you are capable of making a will. You're fit and proper. Okay, when you finish making a will, one problem that I'm seeing a lot is that people not registering it. So when you make your will, just take it down there with your ID card to the registry, the Wills and Probate Registry at the Supreme Court there in Georgetown there, and go register your will. Anybody could take their will and register it. You don't have to be an attorney at law. But the attorney at law would register the will when the person making the will passes on and they didn't register it. Okay, why we register the will? Because it needs to be attached to the application to make the application to become the administrator or the executor of the estate. Okay, so it's very important to register the will. You need to do an affidavit of one witness. In Guyana, I don't see it is attached. I don't see it's a document that is attached and filed same time with the will when it's registered. In Trinidad, a lot of documents carry the affidavit of due execution, they call it. Same time they lodge it, because what happens if the person dies, if the person's overseas and cannot be located, you know, it's very system not really thought out well. They only do, well, as far as I know, they do the affidavit when the will is being opened and is required for the administration, the application for administration or probate. So I don't think people are familiar that they have to do an affidavit of due execution. But so when you make your will, you go and carry it there to be registered at the registry there. Ask them about the witness, the one witness that have to attest to the will, because as you know, the witness currently, you could find a witness, can the witness come to the registry and they have a form there that the witness have to sign up. So is it possible to sign up it there one time? So you know that requirement when you making the application is already covered. The applicant don't have to the trouble of go looking and finding and searching for these witnesses. Okay, so what now I would like to share with you is my special instruction sheet that I have. It is very, very detailed, and I would like to advise you to go to an attorney's office and tell them what have a consultation with an attorney to know what is the best option for you. Not, so you don't have to deal with leave your assets to be dealt with after death and involve the long, convoluted process and additional taxation. Though when you transfer any property, you might be subject to something, but you can see how other means of addressing problems or settling issues and matters before you are deceased. So I have prepared my instruction sheet there. So we look at all the relevant things that we discuss and come to a final decisions as what you can do and what may be more appropriate to be left for your will. So again, thank you for listening, and do like, subscribe to my YouTube channel for more information. Um, leave a comment to let me hear what are some of your experiences. Who knows, somebody up there might be listening and make some radical changes. But for now, we are dealing with the law as is. So thank you so much.